Hey there, happy Thursday. Bill O'Leary here coming to you live as part of our Thirsty Thursday series, um, and where we talk each week about a topic of interest as it might relate to estate planning, elder law, and so forth. So, as I like to say, if you're thirsting for knowledge and information, then you absolutely are in the right place. So, today's topic is how much does probate really cost? So, how much does it cost? What's the cost of probate in Florida? The bottom line is it's expensive, sometimes really expensive. And this is especially true if the probate is a regular probate, if you will, what's technically called a formal administration, a formal probate administration. And so when does a formal administration apply? It's necessary when really the value of the deceased person's assets is more than $75,000. That's it. So as you might imagine, it doesn't take many assets to get above that number and for then the family to find themselves in the world of the full-blown probate. Um, so let's talk about how much probate costs. There are a number of different costs or expenses in a probate. For example, you've got court filing fees, you've got the cost to have to publish in a newspaper, and that's done to allow creditors, potential creditors that you may not know about, unpaid bills, etc., that the deceased had, to give them a chance to come forward and bring their claim against the estate. This is an absolute requirement in a probate. There may be appraisal fees, accounting fees, and other costs. But I want to focus on one particular cost, which is by far the biggest cost in a Florida probate proceeding, and that is the fee that's paid to the lawyer. The bulk of the probate expenses are attributable to that fee that is paid to the attorney who represents the personal representative of the estate. Personal representative is the word we use these days for an executor. Perhaps you've heard of that term. And because the rules in Florida require that a probate attorney be used in most probate cases, attorney's fees are an unavoidable part of the process and an unavoidable cost to the process. So, in Florida, an attorney for a personal representative of the estate can receive reasonable compensation that's paid from the assets of the estate. In other words, the attorney is paid from the assets of the estate, again, assuming that there are sufficient assets in the estate to pay the fee. Now, attorney's fees for a Florida probate are agreed upon in particular arrangement that the attorney and the personal representative agree to. But since the amount that's paid to the attorney reduces the amount that the heirs or beneficiaries would otherwise receive, for that reason, Florida's law says, hey, look, the fee has to be reasonable, because again, it's ultimately coming out of the pockets of the beneficiaries. Well, what constitutes a reasonable fee for an attorney is inherently subjective. Two people can disagree as to what's reasonable, whether a fee is reasonable in a specific case. So what is reasonable? Well, Florida law gives us a very clear answer. The Florida Probate Code gives an objective standard to follow. The probate law lists fees, or sort of a schedule of fees, that if the fee falls within that schedule, that fee is presumed to be reasonable. And so what does it mean when a fee is presumed to be reasonable? What that means is if there's any question about the fee and a judge ultimately has to give his or her stamp of approval on the fee, the judge must uphold the fee if it is an amount that's cited in the law. So that is to say the judge, in making that decision whether to give a stamp of approval, has to apply a legal presumption, okay, that the fee is reasonable and uphold or approve the fee, and can only disapprove the fee if somebody comes in and overcomes that legal presumption, maybe shows there's some other exceptional reason why the fee should be different than what is stated in the law. This is what makes Florida probate very expensive. So again, what's a reasonable fee? Well, A reasonable fee is a fee that's based on a certain percentage of the value of the deceased person's estate. And the range under Florida law is between 3% up to 5% of the estate value. So let's look at the low end of that range, 3%, okay? Here are some examples using that 3% baseline. So if the estate is worth, let's say, $100,000, the fee would be $3,000. If the estate's worth $200,000, then the fee is $6,000. That's what 3% of 200,000 is. If the estate is worth, let's say, $500,000, then 3% of that is a $15,000 fee. If the estate, let's say it's worth $1 million, all in, all the different assets, then that fee comes out to $30,000. And now let's, as a point of comparison, let's use that 5% number, the high point of the range. Let's use that number to base the attorney's fee on. Going from 3% up to 5%, the fees will almost double. And so when is 5% used? Well, it's used when there are extraordinary services, and that's a term used in the law. Well, what constitutes an extraordinary service may be different in each probate case. But extraordinary services can include things like, if there's a contest or a challenge to the will, well, that's an extraordinary service. There's more work involved, and the lawyer is allowed to get a fee using that 5% number. Let's say tax returns have to be filed and tax advice given. That's another example of an extraordinary service. Let's say dealing with a business that the deceased person owned. It is a more complicated thing and a more time-consuming thing to sort of wrap up that business, okay? Another type of extraordinary service is having to deal with real property, okay? And I tell you, dealing with real estate in a probate is not uncommon. The fact is that there's more work involved when real estate is involved in the probate. So getting a 5% fee is usually in order. Now, there is some good news in all of this. The home generally is not included in this calculation. Now, sometimes lawyers will deviate from this fee schedule that's set in black and white by the law, and they may charge by the hour. But I find this is more of an exception to the general rule. If anything, charging a client by the hour is not healthy or good for the client, because really, if you think about it, it creates an incentive, sort of a financial incentive for the lawyer to move slowly and to be very inefficient with their time. Why? Because the slower and more inefficient the lawyer is with their time, the more time that ends up being spent, the more hours that are spent. So in other words, it tends to run up the hours if the lawyer is charging by the hour. Really, one way to look at it is an hourly billing arrangement almost pits the lawyer against the client. Instead of being on the same sheet of music, pulling the same train, trying to get to the same point together as a partnership, it almost creates a tension. And I find that clients usually want the lawyer to not work slow and inefficiently, but instead work as fast as possible to get the probate administration finished as quickly as possible. And so where the lawyer, instead of charging by the hour, knows what the fee is going in, regardless of the number of hours it takes, well, guess what magically happens? The lawyer works more efficiently and more quickly. It creates a financial incentive for the lawyer to move fast. Why? Because the quicker that the lawyer finishes up the probate case, the sooner the lawyer gets paid. So it's often a win-win for the client as well as the lawyer. So as you can see, depending on the value of the probate estate, a probate administration can be quite costly. That's why it's important to consult with an attorney about conducting estate planning before death occurs. A proper and well thought out estate plan that considers all of your assets can take the proper legal steps to make sure your family is not stuck in the probate court system after you pass away. This type of estate plan often can be put together at a fraction of the cost of what your loved ones will end up paying later on if they get bogged down in probate. And many times a revocable living trust is used as a wonderful solution to make sure that the family is not bogged down in that probate process. Frankly, a probate which can last a year or more. And again, during that probate, the estate is frozen, and your loved ones can't get what you'd like them to get during that period. In fact, what they might even need to get. A living trust can make things go smoothly and easily after you die. Maybe a living trust is the right solution for you. Boy, what a gift that would be to your family. So if you'd like to know more about how much probate really costs, or better yet, how to avoid probate and not sticking your family in that morass, and if you'd like to know how maybe we can help, we'd be happy to talk to you. You can book a free 15-minute phone call with our team just by going to our main Facebook page, Legacy Planning Law Group, and selecting the Book Now button. This will give you the chance to tell us what your concerns might be and what your situation is, and also give us both a chance to see whether we might be a good fit for each other. Again, the call is free. Or if you'd rather not do that through the Facebook page, you can just book a call by calling us directly at 904-880-5554. Or if you're not quite yet to give us a call, you just want to check us out a little bit more, you can Google us, Legacy Planning Law Group, and get to our website. So I hope you've enjoyed this talk on how much does probate really cost. I'm planning on giving another Facebook Live talk next Thursday afternoon at the same time, again as part of our Thirsty Thursday series. Same day and same time, but just a different topic. So if you're thirsting for knowledge, we will quench your thirst. So this is Bill O'Leary signing off for now. On behalf of the entire team here at Legacy Planning Law Group, I want to thank you for spending time with us, and go make it a great day.